It is 4:33 p.m. and I call to order the December 6, 2022 Board Workshop. The district is in compliance with the South Carolina Freedom of Information Act by notifying the media of the date, time, and place of the meeting. The district tapes the meeting for accuracy in preparing the minutes. At this time, I yield the floor to Dr. Brent Powers to lead us in the Pledge of Allegiance.
Madam Chair, fellow board members, staff, and guests, please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Do I hear a motion to approve the agenda as presented?
Madam Chair, I move that we approve the agenda as presented.
Thank you, Mrs. Henson. Do I have a second? Thank you, Mr. Anderson. Is there any discussion? All right, all in favor, please say aye. Aye. Anyone opposed? Motion carries. All right, we are moving right into the board workshop. This is under board governance, roles, and responsibilities. Andrea White and Ashley Story founded their law firm in 2017 with the intent of providing high-quality, cost-effective legal services to school districts, educational groups, state agencies, and other public entities. Ms. White practices in the areas of school law with an emphasis on issues complex personnel matters, the education of students with special needs, policy development, and board superintendent relations. She is a frequent guest speaker at South Carolina School Board Association and South Carolina Association of School Administrator conferences. She is here today to speak on board governance and board member roles and responsibilities. And now I will turn it over to Andrea.
How is everyone this evening? Good. Thank you for inviting me to be with you. I was in Spartanburg last night helping them select their new superintendent, so I feel like I've been on a whirlwind tour of the state over the past few days. But what I have been asked to do, and I do this quite frequently, especially since y'all have 3 new school board members, is before you go to the conference in February, to give you some information about what the law and policy say and about what your roles and responsibilities are. Because I think it's helpful before you actually get to the conference and you go through your new board member orientation to have some framework in which to consider everything that's being said to you. So that's what we're going to be doing here this afternoon. If anybody has any questions as I'm speaking, just raise your hand because I think sessions like this are better when it's a two-way conversation as opposed to just me standing up here and talking to you for an hour or an hour and a half. I have worked with every school district in the state of South Carolina at one point or another. I've been practicing law for 34 years now, long time, and all I've ever done is school law. And over the last 34 years, we've seen a lot of changes, and I think we're going to continue to see changes in the next several years. We've got a new state superintendent of education, so I think a lot of what I'm going to tell you today is still going to be in place. But as the new state superintendent changes some things and so forth, some of this may change to some degree. So let's get started. So how many of you know where you can find the laws related to education in the state of South Carolina? Does anybody know? And not Anne-Marie, because she's been in this. Where can you find that? Is there one place where you can find all those laws? The Constitution has a framework, but it is not where you can find the specific laws. Where you can find the specific laws is in the South Carolina Code of Laws, and it's Title 59, okay? So if you look up here, you'll see South Carolina Code Section 59-19-90. 59 is actually the book. And you can go online on South Carolina Legislature online, and click on Code of Laws, and then go down to, it'll say Title 59, Education, and you can find all of the laws that pertain to education, both public and private, K-12 and higher ed. So that's a good place if you ever have a question about, well, is there a law on this? That's where you can go to find the laws. Of course, that's just one little piece of it, because we also have what? We have regulations, Department of Education regulations, which you can also find on South Carolina Legislature online. You can look through all the different regulations that pertain to education. Another source are in the Appropriations Act. Every year, when the General Assembly passes a budget, there are provisos to the budget. And those provisos are good for how long? 1 year, right? Now, some of them are repeating over and over. You'll see it every year. But they're only good for 1 year unless they are, unless they carry over. And so there are a lot of provisos that impact public education that you can find in the provisos. Then, of course, you get into case law, which, we have South Carolina state case law that interprets the regulations and state laws pertaining to education. And then, of course, we also have federal law that pertains to, in particular, constitutional issues that impact school districts, such as the Fourth Amendment with searches and seizures. And the other big one is what? As far as school districts are concerned, what part of the U.S. Constitution? Well, Title IX is not part of the Constitution. It's not an amendment, but Title IX is a big one. But what do we, especially in today's political climate, First Amendment, right? Freedom of speech, freedom to assemble. And we see lots of, and I think we're going to continue to see lots of decisions on the federal level across the country related to the First Amendment as it pertains to free speech. And we're not going to get into, because I could talk about this for hours. I wanted to be a law professor, and I may do that at some point when I retire. But if you sit down and you start reading way back into the 60s about the right to expression and the right to free speech, some of you may have heard of the case of Tinker v. Des Moines, where the big statement that came out of that case is that students do not lose their constitutional rights at the schoolhouse door, right, as far as their rights to freedom of speech. And when you talk about, for example, taking books out of libraries, what does that impact? Freedom of speech, right, freedom of expression. So that's a big one that I think we're going to see more and more case law, because you get into not only with employees speaking out, right, on a matter of public concern. For it to be protected speech, it has to be on a matter of public concern. And then another big place where you see that is today with social media like it is, students engaging in behavior off campus. For example, students making threats against other students or making threats against the school, and then the student gets expelled from school, or they post something on Instagram or Snapchat, or what's the big one now? TikTok. I wouldn't begin to know how to even get on TikTok, but anyway, they post something there, and then they do it over the weekend. They get expelled from school, and then what? They hire an attorney, and the attorney says, well, my client has the right to freedom of speech. And then the district has to prove that in some way the student's actions disrupted the school environment, okay? So that's where we get all the laws that impact school districts. But as far as you all are concerned and what rights and authorities and responsibilities that you all have, the first place to look is in Section 19, okay? So the title is 59, the section is 19, or the chapter is 19, and then the specific section is 90. And that is where in Title 59, it delineates the general powers and duties of school board members on here. There are a couple that I want to point out. Employ and discharge teachers, okay? That is the role of the school board. However, that is pursuant to what? the recommendation of the superintendent. And we'll get into some more details about that, but you have the right to employ and discharge teachers, but that is a right that is contingent upon the superintendent making a recommendation to you. Then you can do what? You can vote in favor of that recommendation, or you can vote against that recommendation, but that's how you act, is pursuant to a recommendation. Another one on here that I want to mention is visiting schools. In the past couple of years in another school district became a big issue as to when and how and why board members can visit schools. That is not only a right that you have, but it's also a responsibility. But when you visit schools, what do you need to do? Right, you need to make sure that you are carrying out that visit in accordance with your board policy that speaks to visitors to schools. Because as a board member, you are still, when you're not in a board meeting, what are you? That's kind of a weird question, but let me ask you, like, well, how do I answer that? So when you are not in a duly called board meeting and you're not sitting here carrying out the business of the school district, you are an ordinary citizen, okay? So what I mean by that is while you have the authority and the responsibility to visit schools, unless you're going as part of an official visit accompanied by the principal or by the superintendent, you're going on an official visit. If you're just going there, you're going as a board member, but you're going individually, then it's incumbent upon you to follow the policy for visiting schools. And that's important to keep in mind, because I've seen board members kind of getting astray with that, and it's led to some bad things that we'll talk about later. And then the other thing I want to mention here is controlling the educational interests of the school district. It doesn't state in 59-1990 anything about the budget, but that is a role that's controlling the educational interest of the district, is doing what? Approving a budget and then amending it as necessary. So, and then establishing the annual calendar, which I just went through a situation in a district in the past 6 months where that became very controversial, the calendar, which you wouldn't think it would be, but modified calendars and so forth, it can become controversial. But that is the job of the board. Did you have a question?
So I do have a question. So many of us are parents of students. And before we got elected to school board, we were parents. Now we're on the school board, we're parents. So do we have to announce ourselves anytime we go to our child's school for something, now that we're trustees?
No. If you are going as a parent, and you were going to have lunch with your child or take something to your child or meet with a teacher and whatnot, you still have to follow the visitor policy for, just like you would for a parent. But you have to think about, I guess a good way to describe this is you have a parent hat or a grandparent hat and then a board member hat. And so if you are going to a school in your role as a parent, right, and you're following the policy as far as signing in and whatever it is you need to do, getting the name tag, whatnot, what you have to be careful not to do is while you're there visiting your child or your grandchild or your spouse, not saying, well, you know, while I'm here, I've been hearing things about Mrs. Green's class, and I'm just going to stop by there and see what's going on in that particular class so that I can report back to the rest of the board. And so you just need to keep that in mind, because employees, well, they know you're a board member, and even if you're there as a parent, they know you're a board member, right? And you have to just keep that in mind, because you don't want an employee accusing you of, well, this board member was out here and the board member said something to me and I don't think they should have done it. So just maintaining your role as a parent, but keeping in the back of your head, I'm still a board member and they're going to know I'm a board member, but I don't want anybody to think I'm using this opportunity to come see what's happening at the school when I'm really there to see my child. Okay, so, whoops, wrong way. So given the statute and what your duties and responsibilities are, how do y'all as a group and as individuals work with your administration? And when I'm saying your administration, who is the one employee that you supervise? The superintendent, right? Good answer. And so that is the one a person that you employ on your own. You employ teachers, but that's pursuant to a recommendation. That's the person that you evaluate. That's the person you go to with questions. That's the person that if you've got a concern, you take it to the superintendent, right? So when you're looking at, well, how does my role as a trustee interact with what the superintendent's role is? First of all, the superintendent is the CEO of the district, right? She is responsible for the day-to-day operations of the school district. That is not the role of trustees. And it is tempting. It is tempting because you've probably, when you were running for this position, had people say to you, well, when you get to be a board member, I know that you are going to take care of the overcrowding at my child's school. Or I know you're going to deal with this football coach that never lets my child play. You've heard it, right? And I'm counting on you. I voted for you, and so I'm going to be expecting you to make sure that that's taken care of. You don't have that power and authority, and that is not part of your responsibility as a trustee. The superintendent implements board policies. Okay, that's another important role. She and her staff implement the policies that you all set. And then it is the job of the superintendent to hire staff, right, to supervise those staff, to manage those staff, and when it is necessary, to discipline those staff. And there are occasions when you would get involved in certain employee matters, and we'll talk about that when it comes to you. But in terms of the day-to-day running of the school district, that is the superintendent and her staff. So then what are your roles as board members? You set the vision and the goals for the district. Now, as far as the setting of the vision for the district, that is in consultation with the superintendent, right? Same thing with goals, because this is to, the ideal school district has a harmonious working relationship between the board and the administration, i.e. the superintendent, which is not to say on occasion that she may make a recommendation and you, for whatever reason, you vote against that recommendation. That happens, and it's okay, right? But, and I'll repeat this several times, once the board majority, let's say she comes to you with a recommendation to hire a football coach, okay? And the vote is 7-2 on that. That's fine, 7-2, the person's hired, but what then becomes the responsibility of those two? To accept the will of the majority. And that is part, if you sit down and read the oath for school board members that the South Carolina School Board Association has on their website, they talk about that. Once the majority has spoken via a vote, then it is your job to accept the will of the majority and to support it publicly, okay? And what I say to boards is, when possible, you want to work out your differences when it's a personnel matter, okay? You want to work out those differences in executive session so that when you get in open session, particularly when it's a very important matter, that you are unified. But that's not always going to happen. I told you I was in Spartanburg last night, and they were selecting their superintendent, and it turned out the board was split to some degree, and I was hoping, and this is a 9-member board, that they all 9 would vote for the superintendent, the person that the majority was selecting. But 2 of them felt like they couldn't do that. And so they voted against the selection of the superintendent. And the board chair was very upset over that. And, I explained to him that you can't control, if people are going to vote a certain way, then they're going to vote a certain way, and that doesn't mean that you're not a good chair, but it does become incumbent upon those 2 board members that they support the superintendent because the majority of the board hired that person, right? Does that make sense to everybody? You develop policies, and, you don't just do that out of the air, right? The school, even though some boards have done that. I give little asides here because I've been doing this for so long, but you generally get drafts of policies from the administration, right? The administration says, I think we need a policy on here's an example, like drug and alcohol testing for student athletes, or drug and alcohol testing for employees, when you suspect that an employee is under the influence of drugs or alcohol at work. The School Board Association also promulgates model policies that school districts use, and, boards will modify those generally based on the recommendation of the administration to fit the particular district. But ultimately, it is your job to give final approval to those policies and administrative rules. What's the difference between a policy and an admin rule? Yeah, exactly. Policy is more the framework of, and sets forth the vision and the goals of whatever, like, for example, staff conduct policies, right? Well, the policy may say we expect all of our staff to conduct themselves in a professionally appropriate way and interact with students, maintain professional boundaries, blah, blah, blah. And then the administrative rule is what? The specifics, right? About here's things that we consider to be misconduct, and here is how we're going to handle it if an employee is engaging in misconduct. So that's the difference between a policy and an admin rule. And generally speaking, a policy requires 2 readings. Do y'all do 2 readings here? And an administrative rule, depending on the district, in some districts, administrative rules are just given as information, and the administration actually develops those. And in other districts, the board votes to approve admin rules, but only on 1 reading. That just depends on your specific board. But that's the difference. And so what I tell boards is that policies generally are something you don't want to regularly tinker with, right? Administrative rules, because it's an easier development process and an easier approval process, that's where you get into more of the minutia, is in those administrative rules. Holds the superintendent accountable. How do you do that? 2 ways. Via her contract, right? The contract that y'all have with Dr. Postlewaite spells out how the board will hold her accountable and how she will hold the board accountable. It's a contract, and a lot of times people don't understand this. It puts obligations on her, and it puts obligations on you, right? Same thing with teachers, right? It works both ways. And then you also hold the superintendent accountable when you conduct her annual evaluation. That is another way in which you hold her accountable based on whatever instrument y'all have adopted to evaluate the superintendent. You vote on superintendent's recommendations, right? That's how you vote, is when she recommends something to you. And then lastly, you serve as a quasi-judicial body in specific circumstances that we'll talk about in a minute. So that's kind of a broad overview of the role of the superintendent and her administration and the role of the board. So, the board has the following functions. We talked about review and adoption of policy. Quasi-judicial. In South Carolina, we have several laws that pertain to the removal of students from school for misconduct, and also the removal of employees for poor performance or misconduct. And let's talk about students first. If a student is suspended from school pursuant to the disciplinary code for some infraction, that student has the right to appeal that suspension, but that does not get up to the school board, okay? Suspensions are handled internally, and I don't know off the top of my head because I haven't looked at your policy recently, but generally it's that if the principal suspends, it goes to the hearing officer or the student services officer, and it ends there, right? They don't have any right to appeal beyond that decision. Other districts, particularly smaller districts, they'll allow a suspension appeal to go up to the level of the superintendent. It just depends on your specific board policy, but the board does not get involved in that, and you do not want to be involved in that, because if y'all were going to hear student suspensions, because there's time requirements, right, as far as this appellate process, that's all you'd be doing. You know, you'd be meeting probably once a week to hear student suspensions, and I know you don't want to do that, and it's not your job. But expulsions are a different animal. If a student is expelled from school for the rest of the school year, they have the right to appeal that all the way up to the Board of Trustees. And the board ultimately makes a decision on whether or not the student is expelled from school. So that is when you would be sitting as a quasi-judicial body considering whether or not the student should be expelled or should be readmitted back to school. And an expelled student, beyond the board, what can an expelled student and his or her parents do? They can appeal that into court. They can appeal that into circuit court. And a suspension, unless there's if a parent doesn't like the fact that their child was suspended, okay, they don't have, the court doesn't have jurisdiction to hear that. You know, if they allege there was some denial of due process under state law or something else, then a court might get involved in a suspension. But that happens very, very rarely. But if a student is expelled, the student and his parent can appeal into circuit court, and it's not a jury, it's a judge reviewing the record of the hearing before the hearing officer and the hearing, any other lower hearings, and then making a decision. But it's important to know that. As far as employees, there are two situations where you, generally speaking, where you would be hearing employee appeals. Does anybody know what those two circumstances are? Yeah, it would be Dr. Postlewaite's recommendation, okay? So if you have a teacher who is a continuing contract teacher, does anybody know what that means? Your older board members do, or those with experience. What that means is a teacher is eligible for a continuing contract on their third year of employment. Once they reach that status, they have a continuing contract. What that means is that before they are terminated or non-renewed, termination's generally middle of the year, renewal is not bringing you back for the next year, okay? If a teacher has a continuing contract, they have the right to a hearing before the school board. And that hearing is much like a trial. And the board sits as the judge and jury. Y'all decide what the facts are. It's just like a trial. It's an administrative hearing, basically. There's a court reporter, there's attorneys for the teacher, there's attorneys for the administration, there's an attorney who sits with the board, and then the board ultimately decides whether to uphold the recommendation of termination. That doesn't happen that often because in most cases, when it gets to that point, the teacher will resign, right? Because especially if they get an attorney and the attorney knows, do I really want to go through this whole process and risk being terminated, and then everybody knows about it and then I don't get another job? But it does happen. And I don't know, Anne-Marie, when was the last time y'all had a teacher dismissal? Yeah. It just doesn't happen. I mean, in a good year, I'll probably have one. In a bad year, I may have three. I mean, it just doesn't, it doesn't happen that often. But it's a big deal when it does. And that's when y'all would sit as a quasi-judicial body. And of course, if it comes to that, y'all would be trained on what your role is and so forth.
Andrew, that's why you don't want to know anything about it.
Exactly. Because same thing with student expulsion appeals as with employee appeals. You want to be able to hear it and make a decision based on what is presented to you during that hearing, right? So you cannot, if people call you on behalf of the teacher saying, oh, I just need to tell you that this teacher is wonderful and everything that's being said by the superintendent about this teacher is not true, superintendent doesn't like the teacher because blah, 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 blah. Same thing with the student. This student is an Eagle Scout, goes to church all the time, whatever. Because what can happen if you engage in those conversations? You'd have to recuse yourself because you are biased, right, potentially biased based on the information that you heard beforehand. So it's important when the superintendent alerts you that we've got a situation that could result in me making a recommendation for termination, and I just wanted to go ahead and tell you because you might be getting some phone calls. what to do. So board members like, what am I supposed to do? I don't want to be rude. You say to the person, I'm sorry, this is a matter that may come before the board, and I want to be able to be fair to the teacher as well as to the administration. So I cannot engage in this conversation with you. I appreciate that you support the person, but I simply can't have this conversation with you, is the way to handle that. Because attorneys for teachers will, if they believe that they can get certain board members off the board by, telling them that they need to recuse themselves, they will do that. Because I've had a situation actually where a lawyer argued that the whole board was prejudiced, and that because of that, there needed to be a special panel to actually consider the termination recommendation. So, you just need to be very careful with that.
And Andrea, the hearing is around, will the district follow its process to get that decision, correct?
Well, with expulsion, generally, yes. With teacher non-renewals or terminations, and let me say this, it's the same standard under state law, whether it's a termination or a non-renewal. Generally speaking, terminations happen mid-year, and they are based on misconduct, where you've got a teacher who cussed out a parent or was involved in an inappropriate relationship with a student, or did something else egregious, got drunk, came to school, had alcohol in their, desk drawer, whatever. That's going to happen, like that happens in November. They're going to be recommended for termination in November. Non-renewals generally are performance-based, where you've got somebody who either fails their formal evaluation, or there are other performance concerns like attendance. You've got somebody who every year misses 30 days, and they've been warned and told, and they keep missing. So those are the two different kinds of cases. And what your job is to look at whether the administration met its burden under the Teacher Employment and Dismissal Act. Okay, the Teacher Employment and Dismissal Act, where can you find that? Title 59, right? And it actually is Chapter 25. You can read all the laws in Chapter 25 that pertain to teachers. And so the standard is that if it is a misconduct case, it lists the kinds of things that constitute misconduct. Insubordination, willful violation of policies and regulations, drunkenness, immorality. I think the language is gross immorality, which I don't know, what is that today? Who knows what that means, right? And so what your job is to decide, because the administration has the burden to prove that the teacher engaged in misconduct. So you listen to the witnesses and say, yes, well, as a matter of fact, the teacher did engage in this misconduct. And even if you think that's too harsh, okay, if in fact that is misconduct and that has been proven to you, do you vote to support it, or do you vote not to support it? Yeah. Generally speaking, I would say support it unless you feel like the punishment doesn't at all meet the crime.
The board gets into a pattern of reversing.
Yes.
Will that board hear more?
More.
So you keep mentioning teachers, but this says employees. Does this apply only to teachers, or is this?
You anticipated my next part. So, okay.
Because you had just said that teachers with a continuing contract have the ability to appeal. Is that only those teachers, if you don't have a continuing contract, then you don't have the right to?
You do have the right to appeal, but it doesn't. So with a continuing contract teacher, okay, that right to appeal to the board is it's a solid right, meaning that the board can't say, well, we don't feel like hearing this. We've learned enough about it. We know you did this bad thing, so we're just not going to hear it. You don't have that discretion. You have to hear it under the Teacher Employment Dismissal Act. If you have a teacher who is on one of the lower levels, right, an induction contract teacher or an annual contract teacher, with induction contract teachers, there are no hearing rights that are provided in the Employment and Dismissal Act. But that induction contract teacher is entitled to what? basic due process. And what is basic due process? Think back to your civics classes. What is basic? What is fundamental due process? That kind of comes after you've gotten to that point, but that is part of due process. That's in the criminal context, okay? In the employment context, when someone is going to be terminated from a public position, okay? Public employees have rights that private employees do not. That fundamental due process is notice. Notice of what? Notice of the thing that you did, okay, that led to you sitting in the superintendent's office or the HR director's office and her looking at you going, this is not good. Okay, so notice of what you did. What's the second part? An opportunity to what? To respond. An opportunity to respond, okay? So that is what your induction contract teachers and your annual contract teachers and your classified employees. Classified employees are those who do not hold a certificate issued by the state of South Carolina. So when you're talking about classified employees, you're talking about bus drivers, teacher assistants, cafeteria workers, and it also could be some people who, accountants who don't have a certificate, other people who work within the school district who are considered classified because they do not have a certificate issued by the South Carolina Department of Education. So with all of those individuals, they have the right to that fundamental due process. With annual contract teachers, they have the right to a hearing before who? Superintendent. Then beyond that, what do they have a right to do? And I'm asking you stuff that I don't expect you to know the answer to. That's just my teaching. They have the right to request a hearing before the board. Do you have to give them that hearing? No. That is discretionary. Same thing with your non-certified employees, okay? And I don't know what your process is in Lexington One for the termination of classified employees, but I guarantee you that it does not give those individuals the right to be heard by the board, okay? It could be, well, we'll talk in a minute about grievances. It could be a specific policy that talks about the termination of classified employees, or it could be incorporated within your grievance policy, but again, you don't have to hear it. What about a grievance? Okay, what is a grievance? It's a complaint by an employee, but it's a specific kind of complaint. And it is defined in your grievance policy, which where can you find your policies pertaining to employees? Section G of the policy manual. And if an employee files a grievance, right, alleging that they have been, that generally speaking, a grievance has to revolve around a misapplication, misinterpretation, or violation of a policy. It's not just, I don't like my principal, I think she's mean to me. That doesn't meet the definition of a grievance. And there's a whole process for grievances. And at the end of that process, as far as the administration is concerned, and that could be a classified employee or a certified employee filing a grievance, they can ask to be heard by the board. Board has discretion whether to hear it. And when you're looking at a grievance, okay, when you were asking a minute ago about process, right? When you're talking about grievances, that's where it becomes really important, because whether the process was followed and in deciding whether or not to grant the grievant a hearing. If process wasn't followed appropriately by the administration, then that's when you would hear it. Not just because, hey, I think we should do this person a favor because she's been a teacher in the district for 25 years. Because you start hearing grievances regularly, you're going to be meeting again every week, right, to hear those grievances. Got off track a little bit, but we're covering some of what we're going to get to. The last sentence on here, bolded, all powers of the Board of Trustees lie in its action as a group, right? You have no authority. When you walk out of here, no authority to make any promises, to take any action. You can only act as a group when you are in a board meeting, and that's very important to remember. That you, and that'll get you out of some situations too, right? If you have somebody saying to you, well, I want you to do this, that, or the other, I'm one of seven. I am one of seven. And when and if this matter comes before the board, I will have the opportunity to give my opinion on whatever it is and also to vote on it. But I don't have any authority other than when the board is meeting and a matter comes before the board. Okay, so, board meetings. And I'm not going, y'all can read. So I'm not going to go through all of this, but I do want to mention a couple of things here. Meeting agendas. And do y'all do it, is it the officers, Anne Marie, or just you as chair? Okay, so the chair. Okay. Which makes sense because she is the one, the board may have some things too that they want placed on the agenda, but generally speaking, it's the board's meeting, but not the superintendent's meeting, but y'all want to know what does she need for y'all to look at, consider, and then potentially act upon, right? And so the agenda is then set for a meeting. Number 4 and number 5, I think are very important. There should be a process in place for other trustees to have input into the agenda, whatever that process is. Because I speak a lot at school board association meetings and so forth. And one question that I'm asked all the time is that, well, I can never, and this is where there are divided boards, right? I can never get anything on the agenda. What am I supposed to do? The officers control it, or the chair controls it. And so there should be something in place where a trustee can get something on the agenda. But having said that, if you have 7 people and everybody wants something different on the agenda, that's not workable, right? But if you've got 3 board members or 4 board members who want something on the agenda, then that means it's important to a critical mass, so to speak, of the board. And so then that would be put on the agenda. And there's different ways to do that. I've worked with boards on, well, how do we go about doing that? But I think that having some process like that really prevents board members from feeling isolated and alienated, and can also keep there from being a big flip, on the board. So that's just something to keep in mind. And then also, does somebody have a question?
Yeah, I was going to ask, can I just ask Anne Marie what our policy is on that?
We actually.
Y'all were working on it, right? Yeah.
And we've had a couple instances where we had items that came for a vote and the board decided not to put it on the agenda. I think that one of the things that, at least for the last couple of years, has been the consideration when items have been sent is, kind of for the good of the group sort of mentality. Is it something that the board truly needs, because we have important things to do and, things that are within our wheelhouse. And, is what's being asked something that is going to benefit the district, or that the board needs to spend time at our meetings discussing. And so, we talked about it in the policy last week about was it the BBAA policy? Or is it BBAA, where a board member can submit an item for a request to the board, and we can put it on the agenda, and the board can vote on it. And we've done that in isolated instances, but typically it's something that falls in line with something that is coming up on the agenda anyway. So,
Right.
And Dr. Postlethwaite has more experience with this as well.
So what's the best way for our board to, but I think this is, like you said, very important, because I know it has been an issue in the past for our, certain people to get things on the agenda. So I don't want that to still be an issue if we can solve it. So what's the best way moving forward for our board to, like, if I feel like something's super important to add to the agenda, do I just, email you or the whole board, or?
Well, and I think what Anne Marie's saying is there's only so much capacity and time in the board meeting. So I personally think agenda items should align with the strategic priorities that we set as a board, and should then speak to how we're executing against that. Now, that doesn't mean there may be things that as a board member or as a board collectively we're asking the superintendent to engage, but whether it makes the agenda or not, again, there's a lot of people that go into these meetings, and so we got to be
you got to use your time judiciously. And one thing I would suggest is if there's something, in particular that any one of you are interested in, to have a conversation with the chair or to have a conversation with the superintendent about that. Because as I was saying earlier, I think all trustees should have the opportunity to offer ideas, right, for the agenda. But if you had all 7 people saying, well, I want to talk about this and I want to talk about that, that's not workable. Right?
And what we talked about with the BBAA policy is if somebody has an item that they want to discuss, is to bring it up and then allow the administration an opportunity to determine what extent resources are required to be able to prepare for discussion of that item. Because, we can talk about things that we hear in the community all day, but she's our person to solve the issues that we hear about in the community all day. And so we need to make sure that the administration is able to come to that conversation on the agenda and say, we're happy to discuss this. We've looked into it, and it'll probably take 36 staff hours to be able to prepare for a meaningful discussion at our meeting in January. And so let's go ahead and put that on the agenda. Because we want the board to decide together how the resources are used to address things that bubble up from the board. Does that make sense?
I mean, I think piggybacking on what Katie was saying is, if there's something that I feel like is important to me, maybe Kathy might agree with it, Katie might agree with it, Anne Marie might agree with it, but the question is, how do I know that you all agree with it? I mean, I guess, I hope I'm not taking words out of your mouth, but almost like, how do I let the board know, hey, here's something that's important to me. I don't know if it's important to y'all, but I'd like to.
Well, I
That's what
think
I'm trying to
open
sort through.
communication between us is critical. That hasn't always been the case.
Right.
Okay.
I think we have a new board here with us tonight, and going forward, I look forward to working with the other 6 board members that are here tonight. And pick up the phone, send an email, garner some support.
Right. And then have a board workshop maybe to talk about what are things for future agendas? What are some things that we collectively think are important, that understanding that, like, for example, we're getting ready to come into budget preparation season. I mean, it's December, but you think about it, April's right around the corner, right? And hiring season, I mean, there's a lot that goes on that it's not necessarily time to talk about getting a new fine arts center, or you know what I'm saying, but having some kind of a workshop to talk about those things. Number 5, and this kind of works 2 ways. Board members should receive their agenda materials in adequate time for study before board meetings, okay? So that is incumbent upon the administration to do what? To get you those materials in time, and then what is your responsibility? To read those materials. And if you have questions about information in those materials, what should you do? Pick up the phone, right? Or email, go visit. Don't wait until the board meeting to say, some question, especially when it comes down to the budget, right? Because those of you who are new, you look at a school budget, you're going to be, because I look at school budgets, right? I'm not a finance person. I mean, I do some school finance stuff, but it's overwhelming. And so you don't want to use a meeting to ask your 2,800 questions because you don't really know what you're looking at. So pick up the phone, call the superintendent, and she likely will say, well, come in and meet with me, and if you need to, meet with the finance person so we can answer your questions. Don't wait until the board meeting and play gotcha and take up everybody else's time.
She has a wonderful point about that. So I do think that a Friday afternoon is not adequate time before our meeting. So just.
Well, that's what I was going to ask. Best practice, because you work with people around the state. Best practice, what's probably an adequate time? 72 hours, a week?
I'll tell you what most boards do. I think a week is too long because things change,
Okay.
right? I do think that if you're going to meet on, what days do y'all normally meet? Tuesdays. I would say, and a lot of boards meet on Tuesdays to get the materials on Thursday. That's generally what I think is best practice, which is not to say that you get the materials on Thursday and then something happens, right? Or for some reason you can't get it a Thursday before a particular meeting because there's some crisis, right? But I think getting it on Thursday for a Tuesday meeting is at end of the day Thursday, right? That gives you Friday. That gives you Friday and Monday to be able to, and the other thing about it is if you get it on a Friday, and the meeting's on Tuesday, you really, you know, you're not going to be able to come in, generally speaking, over the weekend, so that gives you Monday. So if you can get it on Thursday, that gives you Friday and Monday to then study it, ask any questions that you've got before the meeting on Tuesday. That would be ideal. Okay. All right, let's go to personnel. We've talked about this. Evaluating the superintendent, good working relations through the district's chain of command. Now, I do want to mention that. I told you that the only person that you hire, supervise, and control is the superintendent. Should you be engaging in conversations with staff other than the superintendent? Yes. And I'm not saying that, and she may say to you, like, for example, using my example of the budget, right? If you've got some question about the budget and you call her and she says, go ahead and call finance and schedule a time to sit down with them. But what you don't want to do, and this is for your own protection too, you don't want to go in and just appear in the office of a principal and say, okay, I want to sit down and have this conversation with you about some things that I think that are going badly in your school. Her contract says that, is my guess. I haven't seen her contract, but the lawyers who draft contracts, we all pretty much include that same language in there, right? That you engage through her, and then she will go talk to whoever the staff member is that you have a question or concern about. Because if you start engaging with people on down the chain of command and something goes wrong, that can spin on you. And I've had a couple of situations where a board member took it upon themselves to go to a school. There was a complaint, and the board member went to a school and was talking with one of the staff members and put her hand on the staff member while she was talking to the staff member. Well, the staff member didn't like that one bit and was already upset because the board member was saying, now you need to calm down. This is not a big deal. I don't know why you think. So what did the staff member do? Filed a complaint, an internal complaint. And the board actually asked me to come in as somebody who wasn't, part of it to investigate. And the staff member also threatened to file criminal charges for simple assault against the board member, which sounds crazy, but that's not the only time something like that has happened. So it's important to remember you work through the chain of command, because that's what, again, you don't want to violate her contract. That's the oath that you took, and you don't want to find yourself in an orange jumpsuit at, well, it's not Alvin S. Glenn here, at the Lexington County complex, all right? Okay. Community relations. The only thing I want to point to here is looking to the district spokesperson to communicate with the news media. Y'all have a public information officer, right? And generally speaking, that is the person who communicates with the board. If it's not the public information officer, who is it that should be communicating? The chair, right? The superintendent. But the superintendent generally will communicate through the PIO. Sometimes or the board chair. You do not want to go out and start speaking about things that pertain to the board, because you're not authorized to do that, okay? Now, I've had many board members say to me, well, I've got the right to freedom of speech, which is true. You do have the right to freedom of speech, right? So if you go out and speak, what I don't encourage that, okay? But you do have the right to freedom of speech. But if you're doing that, you need to make sure you're saying what? I do not speak on behalf of the board. I am speaking to you as one trustee, and this is my opinion as one trustee. So I'm speaking to you in that role, or I'm not speaking to you as a trustee even. I am speaking to you as a stakeholder in this community, and I am voicing my opinion about whatever it is. But be very cautious with that, because it can create all kinds of issues. Lexington Richland 5 has just gone through a lot with people, with board members speaking and saying things and writing letters on their own, and it created all kinds of dissonance within the district and within the community. So it really is best to protect yourselves and to protect the district to allow the authorized people to speak to the board instead of you.
So I have a question. So we just came back from the Legislative Advocacy Conference, and they were encouraging us as trustees to reach out to our local legislative delegation. So when we reach out to make that phone call or to have lunch or to have a cup of coffee like they recommended, are you doing it as a trustee?
You're doing it as a trustee, and, 'cause see, that's a little bit different.
Okay.
That's different. When you're reaching out to advocate on behalf of the district. But I still think that if you're doing it individually, maybe you have a different view about something than maybe the rest of the board does, and you've learned that through board meetings and conversations, that you say, okay, I'm just one board member, and I don't have any authority to act outside of a board meeting, but I do want to share with you what I think is important. Use some common sense there when you're talking about that.
Yeah, I think she's kind of talking about, people have called us to get, do you have a statement about this?
Yeah,
Or do you have
exactly.
something to say regarding this?
Like a teacher having sex with a student. Don't you think that's terrible?
Do you have a
When
comment on
yeah.
this? And so I think
Yeah, that's what I'm talking about.
kind of what she's talking
Yeah,
about.
so you don't,
here.
and you say no, our official spokesperson is the chair or our public information
And what you'll find, if there's something like a hot button issue, some very persistent reporters will call. They don't, if you give the, I'm sorry, I don't have any comment, they'll call to try and find somebody that they can break down. So just know that will happen. And they know the procedure that they're supposed to call the PIO, but they're hoping that they'll get, the juicy tidbit from calling one of the
And you'll
board
get
members.
emails, you'll get text messages, and what's the other thing that now has just blown up completely? Facebook, social media, groups on Facebook, and commenting on things that have to do with the school district. And you just, I have lots of feelings about that, but you just have to be really careful. You really do. When you put anything on a Facebook page where you say, this is my official Lexington School District One page as a trustee, just be careful with that. Because, we get in any kind of litigation, that's gonna come back. I mean, they're gonna be showing you those Facebook posts and saying, well, did you say this? Did you do that? I mean, it can just again, be careful with
And
that.
speaking from experience, I would say every conversation that we have probably needs to just automatically think that someone's recording you or screenshotting anything that you might put out there, even
Yep.
if you delete it, because it will always come back, especially on social media.
Yeah, it will. Somebody will show it to you 2 years, down the road. They'll pull out something that you said on social media. So just be, and I say this to teachers all the time and other employees, but I think it's also important to say it to board members, use your privacy settings too. I mean, people will look, if a teacher does something bad, let's say a teacher has something on their Facebook page where they're smoking weed or they're drunk or, something else that, and we don't go policing people's social media, but if it comes to us, what do? We have a duty to look into it, right? If it comes to us from a parent or whoever else in the community. So you don't want that teacher who gets in trouble going and looking at your Facebook page and then trying to find something on there to make you look bad, because they're going to bring that up in the dismissal hearing. So just keep that in mind. And number 5 on here, channeling complaints or grievances from constituents through the appropriate channels. That is in the superintendent's contract, okay? If you get a complaint from someone about whatever, about a teacher, about the grass not being cut at a school, whatever it is, you do not what? Take it upon yourself to solve that problem. You say, thank you for bringing that to my attention. I will make sure, you can do one of two things. You can say, I will relate that to the superintendent, or what's the other thing to say? Have you talked to the principal at your child's school? Have you talked to this teacher? Who have you brought your concerns to? So you want to channel them to the appropriate place. You're not taking it upon yourself. Don't ever make promises, and don't take it upon yourself to solve somebody's problem, because again, you can't. You're one person, right? Okay. The superintendent's responsibilities here, again, we've gone through this, and again, I can't reiterate enough that the superintendent is responsible for the day-to-day operations of the district, right? That is not board members. And it's tempting, It's so tempting, especially if you are an expert in something. Each one of you has, based on what you do for a living or what your personal experiences are or your family experiences, you are an expert in one or more areas. But that doesn't mean that you then have the authority to control that part of your experience. May be helpful and so forth, but just remember that the administration is in charge of the day-to-day operations. Okay, we're going to talk a little bit about meetings, which we've really done as far as what the superintendent's role is, and this is exactly what y'all are doing as far as the superintendent identifying topics which the board should address at meetings, giving board members sufficient information for decision making, and then following a meeting, it's her job to implement the decisions that come out of that meeting. She is entitled to attend what? All board meetings unless her contract or the terms of her employment are being discussed. Otherwise, she has the right and should be in all meetings. Personnel, we've gone through all this too, as far as what her job is. And you see number 5 on there, serves as the board's liaison with staff. Okay, and also that she is responsible for supervising all employees of the district. That is not your job. Board meetings, because I want to get to, what time is it? We've still got good time. Okay, so we're going to talk in some more detail now about some specific things. First thing, board meetings. Board meetings ideally should not last for 5 or 6 hours, right? Let me ask you this. What is the average length? And I'm not talking about a board meeting where it's like a teacher dismissal hearing or, the COVID, when we had public participation that went on for hours, right? What is the average length of your board meetings here? Both. Right. Okay. 2.5 hours.
But now I think we're running about an hour and a half, 90 minutes or so. I think
Yeah.
they've been.
That's good, because, I go to board meetings and it'll be midnight, and it started at, executive session went from 5 until 7, and then the meeting is from 7 till midnight. And I can tell you, by 10:30 at night, everybody's like, oh, I mean, and nobody's able to think, everybody's emotional, nobody's able to make rational decisions. And so, in my opinion, a board meeting should not exceed 3 hours. It should be highly unusual that you would ever have a board meeting that would last longer than 3 hours. And I think an hour and a half. And don't cram so much stuff onto the agenda that you can't get through it in a reasonable period of time. And then the job of the chair, and these 5 things here really are, it's the job of the chair, but it's also y'all's job as trustees to make sure that these things are happening, right? And if you've got somebody, and Anne Marie's a strong chair and an experienced chair. There are some boards where they've had chairs who, I don't want to use the word weak, but too nice. You know what I mean? It's like, oh, if you want to talk about this, it's not on the agenda, but go ahead. It's important to stick to the agenda. And if something goes way out here that's not on the agenda, for the chair to say, I'm sorry, that's not on the agenda. We're going to, we're going to table this, have a motion to table the discussion or whatever's necessary, but sticking to that agenda. Number 2, allowing each trustee an opportunity to speak on a matter, right? Once there's a motion and a second, right, and then it's open for what? Discussion. Each trustee should have the opportunity to speak. What I tell chairs, what I think is ideal is to go around the room and say, do you have anything to say? Do you have anything to say? And let everybody speak. And hopefully everybody has said what they need to say, and don't go back around the room again. But if somebody raises their hand and has another, and y'all need to do that, you raise your hand, right, if you want to speak, or however y'all do that. but make sure everybody has that opportunity. Providing public participation and controlling public participation. Over the past 2 years, and, you know, y'all who have been on the board a long time, and those of you who are new have seen it, right, on social media or on TV or whatever, where it got way out of control with public participation, and people yelling and screaming at board members and calling them names, and the police having to get involved and so forth. So it is the job of the chair to control that. And what I tell trustees is that if the chair, for whatever reason, is distracted doing something else or not able to, that the vice chair should step in and say, you know, Mr. Speaker, you know, I'm going to warn you, your time is up, or if you continue to use that language, we're going to ask you to sit down. But that needs to be policed. Conducting legal votes. What does that mean? Making sure that you're following Robert's Rules of Order, right? Motion, second, debate, call for the question. It gets really dicey when you've got an amendment and then an amendment to this amendment, and then, you know, so you need to. Yeah, that's what Anne Marie was saying, and that gets crazy, and nobody even knows what you're voting on at that point. So it's important that you have somebody on the board who, certainly the chair needs to have a working knowledge of Robert's Rules of Order, but, you know, I think that puts a lot on the chair, too, to be the sole
We
person.
just rewrote our policy, giving that responsibility to the vice chair for like
Good.
the parliamentarian side
Yeah,
of it.
that makes perfect sense, because the chair is having to do so many other things that having the vice chair, you know, understand Robert's rules and understand. And I'm not a Robert's Rules expert, and when I go to a board meeting, I've got one board that I work with, and there's a member on there who's cantankerous, and he also is a FOIA expert, self-proclaimed. And so he'll ask about, well, this third amendment to the second amendment to the what? You know, Robert's Rules says da-da-da. I'm like, crap. So then I have to pull out my Robert's Rules. And, you know, and I'll just say, well, I don't know. Let's take a minute. If you want me to go find that out, I will go find that out. But he plays gotcha at board meetings, too. He just likes to do that. But it is important to have somebody who understands, because otherwise, the reason that Robert's Rules is so important is that it's orderly, right? And if you don't follow it and there's a vote that's not lawful because it didn't follow, right, you know, somebody votes on something and there wasn't a second or whatever, it can undo whatever that vote was, right? So it's important to follow Robert's Rules. You know, having said that, there is nothing in South Carolina law that requires boards to use Robert's Rules of Order. I think every school district in the state in their policy says we follow Robert's Rules, because it's the most comprehensive, studied, researched. Sometimes it's a little cray-cray, but you've got to have some way to conduct an orderly meeting. Yes, yep, and continuity, yep. Okay, FOIA, one of my favorite topics. Yes, and that's important because we're going to talk about that some more. Limiting executive sessions to maintain trust within the community. And we're going to talk when we get into FOIA about when can you have executive session, when is it appropriate, when it's not. But I don't know, and let me ask you a question. Do y'all have executive session at every meeting, or only if it's necessary?
Well, only if it's necessary, but it's typically necessary at all of our regular meetings because we have important
Personnel.
recommendations. But our executive sessions, and we adjust the time allotted for our executive session. It comes before our meetings, and we adjust it depending on what the agenda items are for ES. And so sometimes it's 30 minutes, and then sometimes we'll allocate an hour or an hour and a half, depending on what we have. But they're typically pretty swift, and we're done in 10 or 15 minutes.
Yeah, which is good.
Yeah, I just wanted to mention, even though this is a large district, the board approves teacher and support staff hires.
Okay.
So we use executive session to give board members a chance to review those recommendations before they come out and vote, and then they take the vote on that. If we don't have any other legal items or personnel matters, executive session would be very short. But the fact that this board votes on all teacher and support staff and classified staff employments necessitates an executive
Right, and so that would probably be the case at every meeting. You know, I've had some boards who, they have executive session and they have an hour or 2 hours regardless of what the topics are. And what that leads to is what? Public question. Like the regular meeting may be an hour and a half and then executive session is 2 hours. And it's like, what are you doing? Like you're conducting more business in private than you are in public, so you must be doing something wrong. You jump from this to that, right? But you understand that's kind of what public perception is. So,
Well, Andrew, and I'll just add, that's one of the reasons that I like the way we have our meetings structured with the executive session before, because we have our meeting times hardwired into our policy. And so we've set a line in the sand for our executive session to end so that our regular meeting can start. And so I can only think of one time in the last year or two that we went over a few minutes on our executive session. So we do have them, I mean, they're pretty quick, just so that we can move on to the open.
get what you've done and then come in.
Right.
And of course, you can always go back into executive session at the end of the meeting. If you're in the middle of a discussion and, you know, it's time for the regular meeting and you know it's not going to be just 5 minutes over, it's going to be another 30 minutes, you can always continue executive session at the end of the meeting, and that doesn't violate FOIA to do that. So good. It doesn't sound like y'all are overutilizing executive session and creating that perception of doing business, you know, behind closed doors. Okay, so FOIA. It has two purposes. It requires public bodies to do what? To operate in the sunshine. The South Carolina Freedom of Information Act is also known as the Sunshine Law, right? And then the other thing is that it allows the media and citizens to obtain copies of public records, okay? With y'all, with the board, the part that you're generally most concerned with is what? The first, operating in the sunshine as far as your meetings, right? And making sure that you are not discussing things in executive session that are not proper for executive session. As far as the second part about obtaining public records, that's generally, again, your public information officer who handles Freedom of Information Act requests. And so the district may get Freedom of Information Act requests that y'all don't know anything about necessarily, right? And then handling those. But you also may get a call from the superintendent saying, we've gotten a FOIA request, and part of the request is for copies of your emails that you have sent as board members regarding district business. Are those subject to disclosure under FOIA? Yes. Does it matter whose technology you're using? Nope. Nope. Your personal cell phone, your iPad, your laptop, it doesn't matter. If you are talking about district business, that then is a public record that's subject to disclosure under FOIA. So before you send any email or text messages too, right? Text messages are the same thing. Think about if we get a FOIA request and I have to turn this over, what is the impact going to be? Just keeping that in mind, that whenever you're sending something, at some point, it may be on the front page of the newspaper or on Facebook. So just remember that.
I guess you're speaking specifically of us communicating with other board members?
Not necessarily. And let me say this about that too. So I'm talking about you communicating with other board members, but it could be you communicating with a citizen in the district, or with a parent, or with the family of a student. You know, it could happen. It could happen in any way. I'm going to use another Lexington 5 example, that one of their board members sent an email to a parent that was dismissive of the parent, and she thought the parent was her friend. Well, don't ever think, you know what I'm saying? People will. And so that email ended up being the subject of a FOIA request, all these emails, and then there was that email. and the board member was defeated, and I don't, that might have been part of it, but, just keeping that in mind, whoever you're communicating with, if we get a FOIA request, you may have to turn that over. So, under FOIA, these are, and y'all will, at your, at new board member orientation in February, a lot of times they'll ask me to speak on FOIA. I don't know if I'm doing it this year or not, but you'll have an hour of just Freedom of Information Act training. So I'm just kind of, so y'all don't get there and are like, ooh, I'm just kind of giving you an introduction to this. So a public body, what FOIA says is that it pertains to all public bodies, which obviously you all are a public body. If you have committees of the board, that is a public body. Does it matter how many board members sit on that committee as to whether or not it must follow the requirements of FOIA? It doesn't matter. It could be one board member and 3 administrators and 3 parents and 4 students, right? That is an advisory committee, and that means that that advisory committee must operate within the parameters of FOIA, as far as posting their meetings and having an agenda and so forth. And it doesn't matter what you call it, whether you call it a committee or you call it an advisory group. If the key is, if that group is going to report back to the board in some way, whether that's somebody standing up and talking to y'all, or whether it's them writing a report, out of that advisory group or committee and it coming to the board, that is a public body, and they have to operate pursuant to FOIA. An interesting question came up last year as to whether or not meetings of the board officers and the superintendent, whether or not that was considered to set the agenda, whether or not that was an advisory committee of the board. I don't think it is, but there's a question about whether it is. But since y'all just have the chair and the superintendent, and you don't have the other officers, I don't think you really get into that. But that's a question that came up recently. Again, Lexington 5, they said all kinds of they created some law over the past few years. What is the definition of a meeting under FOIA? Yes, it's a quorum, and it is when a quorum meets to deliberate, discuss, or act upon a matter, okay? The reason I'm saying this is y'all were at the convention, not the big convention, but the legislative advocacy. How many of y'all were there? 5? That's a quorum, right? And did y'all go to dinner together? Okay. Did you send notice of that to the media, that you were going to dinner together and the agenda was appetizers, dinner, dessert? No. Was that a FOIA violation? Why? Exactly. You were in a social situation, and that is fine. Okay. If somebody said, well, don't you think that the new such and such school looks great, with those new paint colors? That's okay. I mean, that's just conversation. But I will caution you at these conventions, because more and more media people and other people from the outside are coming to these conventions, and they're watching. And if there are 4 of you huddled over in the bar or in a corner of a room, and you've got your heads together, right, and what does that look like? It looks like a meeting, okay?
And Tracy notices a lot of stuff, even if we're not doing business.
Yeah, you've got to be careful of perception, because when you huddle together in a corner of the room and you're all leaned in, it looks like you're talking about something that you don't want anybody else to know about. So just be aware of that, okay? Because you don't want to be accused of having an unlawful meeting. It just doesn't look good. What is considered a public record for purposes of FOIA? We just talked about that. If it's anything to do with district business, it's generally considered to be a public record. If you keep notes, this is a good question. So, I'm a note taker, and during meetings, I'm always taking notes, and I see you're doing that too. Are your notes considered to be public records for purposes of FOIA? Yes. Only if what? They're not, unless you share them Okay? Yes. So as long as you're taking notes and you're taking them home, now, if you're sharing them with your spouse or whatever, that's different. But if you start sharing them with other board members or members of the public, they become a public record. Now, having said that, because there's always a caveat, because that's why the typical lawyer answer is it depends. Whenever you ask a lawyer a question, they're going to be like, it depends, right? So your notes could be subject to what? Having to be turned over in the context of litigation, all right? So if the district gets sued, and if the lawyer on the other side is particularly astute, he or she may very well ask for, if it's something involving the board, for any and all notes, documents, blah, 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 that you have. Now, if you don't have them anymore because you keep them for a while and then you destroy them, nothing says you have to keep those forever, but you can't destroy them after we get a discovery request for them, because then that's called spoliation and you can go to jail for stuff like that. You know what I mean? It's destruction of discovery documents. But you can keep your notes and not worry about those being subject to FOIA unless you share those with somebody else. We talked about texts and emails, public records, because you're communicating with somebody else, right? The penalty for a FOIA violation, what's the penalty? There is a, that's a good guess. There is a fine can be assessed against the school district. And I don't know if it spells out in the statute what the fine is. I think it's discretionary with the court to impose that fine. But there also can be criminal sanctions under FOIA, which is very interesting. I've never seen that exercised in South Carolina, but it could happen. The other thing is if you get a FOIA lawsuit, right, if you're sued by somebody requesting documents, if they win in court, then a fine can be imposed. You have to turn over the documents, and they can get attorney's fees. And that's the big thing. Because even though, that's why lawyers love cases where they can get attorney's fees, right? So, the fine may be $1,000, but the attorney's fees are $50,000, right, if you lose. So it's important to keep that in mind. And then when FOIA was amended recently, most recently, which I think was in 2017, they put a provision in there because a lot of not just school districts, but other public entities were saying, we get all these FOIA requests, and it's repetitive and burdensome and harassing and onerous and all those things. So the General Assembly put a provision in FOIA where a school district can take action against someone who is making FOIA requests that the district believes, and the language is in there, like I said, burdensome, oppressive, designed to harass. It's all laid out in the statute. While that's in there, I discourage boards from doing that because you want to create an enemy and you want to lead to lots of questions about why aren't you just giving us this stuff, right? That's the way to do it. But that is in FOIA. And I know of at least one district that went that route and it did not turn out well for them. But it is there.
Could you, real quick, bullet 2 where it says what is the definition of a meeting under FOIA? And
Right.
we talked about a quorum. That's not just in person, correct?
Correct. A quorum is the convening of a majority of a public body by any means, including, I think the language is, isn't it sick that I've memorized all this stuff? Whether it's corporal, right, meaning in body, in person, or what? Electronic communication. So here's how this gets to be a problem, right? So the one board member sends an email to the superintendent and asking a question. Totally legit, right? But then that board member copies all the other board members on it. Then another board member says, well, while this board member is asking about this, I want to chime in and talk about this. What are you doing? That is a meeting, right? And that is a violation of FOIA. So if you are going to send an email to the superintendent or to another board member, do not copy the rest of the board on it, because people can't stop themselves from chiming in, right, if it's something they've got an interest in. And right then you violated FOIA by doing that. Same thing with texting or emailing. You stay away from it. Okay. FOIA requirements, you have to have an agenda. the agenda can be amended up until the 24-hour deadline. After that, and this is again amendments to FOIA back in like 2012, you've got to have a 2/3 vote to add something if it's after the 24 hours, and then a final action where you're going to take a final vote on something. For example, second reading on a policy can only be amended with a 2/3 vote and a finding of an emergency circumstance. And the reason for that is that in one of the Spartanburg school districts, there was something about they were going to use a country club's golf course for their golf team, and the district was going to pay for the golf course to be like upgraded and all fancy and everything. Well, the board members knew that that was going to be controversial in the community. So what did? They didn't put it on the agenda. So at the board meeting, they added it to the agenda to have a vote on doing these improvements to the golf course. And there was a lawsuit over it, and that's when, because the statute used to say agenda, comma, if any. And the General Assembly said, well, not only do you have to have an agenda, but now we're going to put in place the only times that you can amend it. So that is now in FOIA. And FOIA, I told you about Title 59. FOIA is in Title 30. If you ever want to sit down for some light nighttime reading, you can read the Freedom of Information Act. Because I learned something new, so, because I deal with a lot of stuff a lot of the time, but then I'll see something obscure, Okay, are we doing okay at 6? You need me to speed up a little bit, or, Dorita, are we okay?
I want you to take all the time you need with the board. This is really important.
Okay.
We just need to share some information with the board about one of the schools that's in our bond referendum. They're not voting tonight.
Okay.
They vote next week. We just want to make sure they have advance notice.
Gotcha. Okay, so we'll take another 15 or 20 minutes or so. So
Can
I just want to,
I'm sorry, real quick. And it hasn't been an issue the last 2 years that I've been on the board, but what happens if something is urgent and we need to come together for a meeting?
FOIA does allow for boards to have emergency meetings. You have to give 24-hour notice of the meeting, right? But if it is an emergency, what FOIA says is that you give as much notice as practicable. And at the start of the meeting, you would state what the emergency is. And an emergency would be a true emergency, like the roof fell in at the high school, the superintendent was hit by a truck. I mean, it's something that's truly an emergency. It's not just, well, we should have put this on the agenda and we didn't. We forgot to put it on the agenda. It has to be a true emergency. But FOIA does provide for that. Executive session. There are other reasons that public bodies can go into executive session, but that are stated in the statute, okay? But these are the reasons that most school boards go into executive session, and these are the only things that can be discussed in executive session. Personnel, student matters, contract negotiations, legal matters related to, just because your lawyer is there, okay? Because some boards thought, well, I know what we'll do. We'll just have our lawyer come to all of our board meetings and sit in executive session, and then we can talk about whatever we want because the lawyer's there. It's not right. It has to be something that is subject to attorney-client privilege, which would be a pending, threatened, or potential claim. Because I get asked to talk a lot about policies and whether or not a district should adopt a certain policy. And they've talked about me doing that in executive session. I'm like, no, I can't do that because that is not attorney-client privileged. That has to be in open session. Personnel matters, it has to be specific personnel matters and specific student matters. So for instance, if you're going to talk about doing a salary study or changing your salary schedule, you cannot do that in executive session, okay? Now, if you're going to talk about if we change the salary schedule, what does that mean as far as how these 4 people are going to be paid? That could happen in executive session. But if it's just a general discussion, it cannot. Does that make sense to everybody? And then, of course, contract negotiations, security and safety measures, and then investigative proceedings related to criminal conduct. It is up to the board to police itself in executive session, to make sure that when you go into executive session, you are required to go into executive session. I make a motion to go into executive session to discuss the employment of personnel. Perfectly fine. You get into executive session and you're talking about employment of personnel, and all of a sudden one board member says, well, while we're in here, I want to talk about a piece of property that I think we ought to think about buying, okay? Now, sale, and I didn't put this on here, but the sale or purchase of property is something that can be discussed in executive session. But why is that a problem then? It wasn't part of the motion. It wasn't on the agenda, that's why you were going into executive session. An executive session, I call it executive session drift. It happens all too frequently. And again, it's usually the chair, because the chair is the one that controls the meetings, but it's really incumbent upon each of you. Because sometimes the chair is the one who's doing the drifting, right? To say, wait a minute, that is not why we came in here. We cannot talk about that in here. You know, we need to go back to the specific reason that we came in here. I've had some boards actually put a poster on the wall in the executive session room that says, these are the only reasons we can be in here, right? And so then point at that and say, that's not what we're doing. Okay, and what can happen if you violate executive session? Two things, okay? First of all, executive session is supposed to be what? Confidential, right? So what can happen if a board member violates the confidentiality of executive session?
Subject to being FOIA.
Well, we'll talk about that in a minute, because one thing is, if you get into executive session and you talk about something you're not supposed to be talking about, right, because it's not proper executive session material, and some board member goes and blabs to a reporter, you could be sued, right, for violating FOIA. But let's say in executive session, you're talking about a personnel matter, and the superintendent comes to you and says, I have received a report that one of our teachers is involved in an inappropriate relationship with a student. It is being investigated. It's highly confidential. I will keep y'all posted on the matter. And then, and she tells you who it is, says who the employee is. And then a board member goes out of that meeting and discusses that information publicly. What can happen to that board member? Well, you're right in a way, okay? There is nothing, and I think this is unfortunate, that there is nothing in state law that says that if a board member does that, there's some hammer that falls on their head, right? Or they're kicked off the board. There's not anything in state law that says that.
I have read in the FOIA laws for South Carolina that it is against the FOIA law, but if you look, there's no remedy.
There's no penalty.
There's no
penalty. And so what can happen is that the board can censure a member for that. They can do that privately in a discussion with the board member, and usually that would be the officers talking with the board member about, you took an oath to preserve the confidentiality of executive session, and you didn't do that, and that's a problem, and we expect you to adhere to what your oath is. It could become a public sanction where there is and that would be on the agenda, censure of whatever board member, and there would be a motion to censure, a second discussion, and a vote. So that could happen. But separate and apart from that, and I guess the more important thing to keep in mind as an individual is that if you are violating the confidentiality of executive session and you are sharing information that is potentially defamatory about an individual, then you could be sued personally for that. And you all have what's known as qualified immunity, meaning that as long as you are, same thing as school employees have, as long as you are carrying out your duties and responsibilities in accordance with what your duties in good faith and keeping what we talked about with 59-1990, your duties and responsibilities, the school district has a duty to protect you legally. And the school district's insurance company has a duty to protect you legally. But if you go out on a tangent and you're out talking about, well, let me tell you about Mr. So-and-so and what I heard, and I've heard it at church too, that he was a Sunday school teacher and there were always questions and so forth, guess what might happen to you? You get sued personally. And what is the school district going to do? You're on your own. And the insurance company is going to do that too. So that's just something to keep in mind. Do the right thing and don't divulge what happens in executive session, but also for a self-preservation reason, don't be sharing that.
Andrew, what I would add is, as directors of Lexington One, we have an obligation first and foremost to the executive session. So the remaining board members may also issue a statement making it clear that that board member was alone.
Yep. That was not authorized. And in fact, I have advised boards to do that, where we had a rogue board member, and the board was very concerned that if they did not come out and distance themselves from that board member, that they were going to get caught up in whatever litigation might result. Yes. Absolutely. Okay. I'm not going to, y'all will get a session on ethics as part of your training because it's required. You have to be trained on ethics and FOIA, and there's one other topic. Title 8, okay? We talked about Title 30, Title 59. Title 8 is where you can find the ethics laws. And I just quoted one of them on here. The big thing is that you may not use your position as a board member to obtain an economic interest for yourself or a member of your family, okay? That's the most important thing I think that comes out of the Ethics Act, okay, is that so if your family member, let me give you an example. If you have a family member who's an employee in this district, and let's say they're a principal, and the board is discussing a 5% across the board increase for principals, what do you need to do? Recuse yourself. You must make your relationship known to the board. It's recorded in the minutes, and you must recuse yourself.
Just clarifying, because we asked that question last year, I believe. We were giving a $2,000 bonus or whatnot, and at the time, we had, 3 employees who had family members, and we were told if it was across the board,
Then you can vote.
we could vote.
Yeah, that's
But
correct.
if it was specific to, like, our family members, we couldn't.
Yes,
So,
if it's across the board, so if your relative, and the Ethics Act lists what they consider to be immediate family members, okay? It's specified in the Act. But if it's an across-the-board increase and everybody's getting, but you see how I said principals, because once you start narrowing it down from, the thousands of teachers, and then you've got 40 principals or whatever, and I tell board members I would err on the side of disclosing and recusing to avoid even the appearance of impropriety, because the Ethics Act talks about the appearance of impropriety. The other thing, as far as the Ethics Act is concerned, you cannot use your district email address, district technology to in any way influence the outcome of an election. And that happened in another district where board members were sending emails encouraging people to vote for a particular candidate, and they were using their district email address. Can't do that. The other thing I'll mention about the Ethics Act is when you do your economic statement of interest and your declarations that you have to do every year, don't be late doing that, because the charges, it's a daily charge, and then interest starts to tack on, and next thing you know is $15,000, and everybody's looking at you on the board saying, what in the world, right? So I tell board members to err on the side of disclosing. If you're because when you were at the conference in February, you're going to have a lot of vendors who may want to take you out to dinner. Is it okay to go? Yes, unless what? If you have a RFP out or an invitation to bid, and somebody who's in that business, let's say fencing, right? You're getting all your playgrounds fenced or whatever, and that you've got an RFP out for that, and a fencing manufacturer is at the convention and they want to take you out to eat, you can't do it. You cannot go. if you do, you're violating the Ethics Act. And vendors should know better, but they don't. They're not the ones who get in trouble. They're not subject to the Ethics Act. It's y'all who are subject to the Ethics Act. Now, if you have a relationship with a vendor and you don't have any open RFPs or invitations to bid, it's perfectly fine. You're not violating the Ethics Act by going out to dinner or accepting coffee or even accepting like tickets to a football game. But what must you do? Put that on you must disclose that on your statement of economic interest. So just keep that in mind. And I'm not going to spend any more time on the Ethics Act because, like I said, y'all will have an hour of that from the head of the Ethics Commission. But they do advisory opinions. You can go read their advisory opinions. And Megan Walker, who is the director now of the Ethics Commission, she's really good if you just call and pose a question to her. She's great. Her sister used to work with me, and Megan's a great resource for that.
And Andrew, I'll just add, one of the things that we have historically done with our SEIs is like, we'll get incidental gifts during the year from schools, cups, T-shirts, things like that. And we put those on our disclosure as well, just because technically our schools have an economic interest in our activities.
Right.
And so we lump them together and put like incidental gifts from schools and.
You don't have to list an apple
Right.
and a pencil and a,
Right, and an estimated value of, $100 or $150 or
Right,
something like that. But
right.
just, for the T-shirts and things that you might get along the way.
Yeah. You're better off again to disclose it than
Andrew,
not.
do you have a dollar amount that is, I have been told by two people at the Ethics Commission, two different dollar figures. One was if it's under 25, don't worry about it. One was if it was under 15, don't worry about it.
I've always heard 25
Yeah.
is what I've heard. If it's under 25, don't worry about it. But if it's over that, then, if you go out for dinner at one of these conferences, it's going to be over $25. Now, if somebody buys you a Chick-fil-A meal, don't worry about that. But anything more than that, I would go ahead and put it on there. Because people use the Ethics Commission politically, too, unfortunately. And, it's supposed to be secret. If you file an ethics complaint against someone, they're not supposed to disclose it and listen until there's some finding. But, that's kind of all gone out the window now. So you just want to avoid the appearance of impropriety.
Thanks. I'd just like to say, when you're in a business of building schools or you're ready to buy new technology, it just isn't a good practice to go to dinner
Right.
with vendors. And if for some reason you need to go, my advice to you would be to pay for your own dinner and get the receipt.
Yeah, I think that's,
It's just not a
because
good
again, it's the
practice.
appearance of impropriety, and even if it's not violating the Ethics Act, do you want to have to explain that to an investigator with the Ethics Commission? And they carry guns. I didn't know that. I just thought that was so fascinating. This was several years ago, and there was something that, and it was like he had it on his leg, and I'm like, wow, y'all take that stuff really seriously. So that's all I'm going to say right now about the Ethics Act. And then, of course, if you look through your materials, you'll see, and we've covered most of these, the common ethics questions. Potential landmines, we talked about these two, allowing your role as a parent, spouse, or grandparents to overlap with your responsibilities as a board member. Just keep that in mind, that you wear those two hats, but people in the schools are going to say, oh, that's the board member, not that's Mr. Rice, the daddy of so-and-so. Visiting schools without following proper protocol, failing to maintain the confidentiality of executive session, and failing to accept the vote of the board majority. Same thing here. We talked about all these. Playing gotcha at board meetings. And I say this to the superintendent and to the board. That is not the place to play out your personal dissatisfaction with something. Like I was saying, when you get board materials, if you've got a question or a concern, raise that before the board meeting. Because when you get into a board meeting and a board member or the board is trying to make the superintendent look bad, and this is human nature, okay? What's the superintendent going to do when they get the opportunity? They're going to spin it right around on the board. That's just not the way to do business, and it creates distrust from the public. If you're going to go out for a bond referendum, what are people going to say? They can't even get it together internally. Why in the world would we entrust them with a $185, bond referendum, right? So just remember that. That is not the way to do business. Social media use, we talked about that. Board members acting individually and not as a group. You only have power when you're in here. So, 6:15, 6:18, not bad. So, thank y'all. Thank you so much for inviting me. And I will be at the conference in February. Like I said, I may be speaking, but if not, I'll be in and out. So, any questions that you've got or whatever, I'm happy to talk to you. So, thank you.
All right. Thank you, Andrea.
One of my favorite things to do is to train board members. I'd rather do this when something bad has happened. That's when you don't want to see the lawyer. You want to see the lawyer in a proactive thing, right? Thanks, y'all.
Madam Chair, could I make a motion that we take a 10-minute recess?
It's actually in the agenda that way, so thank you, Mr.
Very
Anderson.
good.
No motion is necessary. Let's take a 5-minute break, all right? believe we are all back. And Dr. Postlewaite, I will turn this part of the workshop over to you.
Thank you. We'll be as brief as we possibly can this evening, but we want to make sure that you have the information you need in order to take a vote this coming Tuesday that would allow us to go ahead and break ground on one of the elementary schools that we still need to build. There are 2 elementary schools that still need to be built in the building program. There were a lot of complexities and challenges with the last building program, namely COVID happened in the middle of it. And with COVID, it was difficult to predict accurately the number of students who would be returning to the district after so many left all over the state. Wherever we were dealing with these same challenges. It was difficult to get employees for the contractors to come to work. They weren't allowed to work for a little while, and then when they were able to come back to work, it was difficult to keep a workforce going, especially after a building was roofed in and had the windows in. And then on top of that, we're all familiar with the supply chain issues that have created price increases that every family is dealing with. The school district is not immune to that. So that has thrown off the rhythm on the funding for the building program. We want to talk with you tonight about the elementary that's in the White Knoll area. We need a vote from you next week that Mr. Warren and Ms. Miller will explain. It gives you a whole week to ask questions you have, and then in early February, we'll have a workshop devoted only to the building construction program with a retrospective. Here's where we were. Here's the tracking of the finances all the way through. And then here's what we need to do for the one final school remaining. So with that, I'm going to turn it over to Mr. Warren and Ms. Miller.
Thank you. Good evening, Madam Chair, members of the board, Dr. Postlewaite. Thank you for the opportunity to share tonight regarding our next large capital project, which is elementary school number 19 in the White Knoll attendance area. I know that we just finished a board session on governance and responsibilities, but I want to bring you below the line for this presentation, including specific information on this project and options for our path forward with it. And then next week, like Dr. Postlewaite mentioned, on the 13th, we would ask for you to go back above the line and approve the budget for this project.
All right, before we get into much of the presentation, wanted to just let you know I had a handout with 3 different sheets for you. That top one there, this is just for the new board members. This is the monthly report that is provided to the board. We did, as discussed, change the format slightly. So this is the revised format. You will see there is now a transfer column and an encumbrance column. Again, those are very normal to have transfers. We are estimating these project costs, that some are going to come in under, some are going to come in over, and you just reallocate those funds amongst the same projects. You're not adding any new projects. It's still all the same items that were in the referendum. And so you'll also notice to the far right of the column that says balance, that's the second to last column, you'll notice a letter C after some of those, and those are for projects that are completed now. We have those marked that way. And then lastly, going to the third line item from the bottom, you'll see a new row called under budget closed project amounts. Those are the ones that were closed. Those are the remaining amounts that have not been reallocated to projects that are already listed above. And you can see we have approximately $820,000 that is available to be reallocated for projects that may go over.
Just for clarification, can you state what encumbrances?
Oh, yes, sir. Sorry, I get lost in my finance brain. I just think everybody knows exactly what I'm talking about. Encumbrances are for expenditures that we've committed to spending. So we've done a purchase order already to the vendor for those. We know they're coming up. That amount will fluctuate. That amount is not precise. It's going to go up. It's going to go down. Just like your transfer amount is going to change each month. That's why they were not originally included in this report, but with transparency, we decided to go ahead and bring them in there, but the board needs to understand they are going to fluctuate every month. Those are going to change.
To provide the framework for elementary school number 19 project, this budget was developed in 2017 along with the other projects in our 2018 building program through a facility study with MBCon. You see in the presentation the allotted budget for this project is $37 million. And once again, this is elementary school number 19 in the White Knoll attendance area. This budget was sufficient based on the market conditions in 2017, plus typical inflation. But as you know, like Dr. Postlewaite mentioned, we have not experienced typical inflation over the last couple of years since 2017. The plan for this school was to open in 2022, 2023, but COVID brought with it labor and supply chain issues that paused construction for this school, and also a pause in enrollment growth that we have not seen in 15 years. What these factors did was they actually provided an opportunity for us to watch the market and see if pricing reduced to pre-COVID figures. And as you know from typical day-to-day expenditures, that just has not happened. For the benefit of our new board members, and as a refresher for the rest of the board, here are some images of school site for ES19. This is a 33-acre site that is located right off of South Lake Drive. Number 6 highway runs right here. If you're familiar with the White Knoll attendance area, I'll give you a little bit higher view here in a moment. But this is heading down towards the Pillion area. This is Bluefield Road. If you're familiar with this area, this is the Blueberry Patch right here off of Bluefield Road. And this is the site, once again, 33 acres that has been purchased and is where the school is planned to be constructed. To provide a view a little further out, perspective on where the site sits relative to other schools in our district, the site is right here. This is elementary school number 19. This is South Lake Drive, number 6 highway, and Bluefield Road is right here. Going up number 6, you see Platte Springs Road. This is White Knoll High School, sits right here. Saxagoff Elementary School sits right here. Heading down Platte Springs Road, you see Carolina Springs Middle School, Carolina Springs Elementary, and then right up Longs Pond is Deerfield. It sits right here. And then right above I-20 here are the Pleasant Hill schools. The impact for this school, ES19 could provide relief for several schools in the Lexington White Knoll attendance area, Carolina Springs, Deerfield, Pleasant Hill, and possibly Saxagatha are all schools who could be impacted as we will undergo the attendance line review process December of 23 through February of 24 if we move forward and break ground in January. The design of this school is a prototype school that we have done with our elementary schools and middle schools through this building program. This was used for Rocky Creek, Meadow Glen, Deerfield, and Centerville. A little over 128,000 square feet, 1,000 student capacity. Jumper Carter Cease is the design firm, and Thompson Turner Construction is under contract to build this school for us. And once again, the plan with your blessing and your vote is to move forward and break ground in January of 23 with the completion and opening of August of 2024. That is a 18-month build for this school, which we feel like is attainable, but it's going to be, obviously a lot of work on our behalf and also the contractor to hit that deadline, but we're ready to get rolling with that project.
And Mr. Warren, remind me and the rest of the board, isn't there a subdivision right adjacent to that school with like 1,000 houses or something?
Yeah, there's Bluefield
Yeah.
is right across the street.
Yeah, so
It's still building out, very
so,
large.
Some of the redistricting, depending on when those houses get permitted and families move in there, it'll just essentially pull all those kids back.
Correct.
Closer to.
Correct. And when I say impact, I don't necessarily mean, all those students would go to elementary school number 19. There could be some shifting from, like we've done before, from one school to provide that relief that is needed now that our enrollment has bounced back. The site layout you see here for ES19 shows the campus at the intersection of South Lake Drive and Bluefield Road. As I noted previously, this is a prototype design, you will see the similarities to most recently Centerville Elementary School. The main entrance to the school will be right off of Bluefield Drive here with the bus access, service drive, and also the majority of staff parking back here will be off of South Lake Drive. You see the necessary linear footage we put in place for car stacking. The goal is always to keep vehicles off of the roads at especially not so much arrival, but dismissal. And so we do provide linear footage to make that a reality, as well as the fire access road that is required that goes around the site.
Mr. Warren, can you remind me, we go blueberry picking there often, but that point on South Lake Drive, is that 2-lane or 4-lane?
It's 2-lane.
It's 2-lane at that point?
Mhm. I gotta skip one. So here's a rendering of the front of the school, even with the prototype design. We do work with our design firm to provide each school an aesthetic identity through colors, patterns, layout, not just on the outside of the building, but also the inside. That part of the process is very important to us. We don't want each school to be identical. We want them to live on their own, to have their own unique school identity, and we accomplish that through aesthetic features, colors, brick selection, and that would be the case here for ES19 as well. Moving to the cost part of this presentation, I wanted to begin by providing information on historical construction costs with recent Lexington One projects. So I'm going to turn and look at the slide, if that's okay. So going back to Beechwood Middle School in 2017, that was not a part of this building program, but it is a recent project that we constructed. In 2017, the building costs, and we're looking at building costs here because that's more of a really not apples to apples, but it's a better comparison. When you're looking at building costs and square foot costs, much like when you're pricing building a house, you're always interested in what is that square foot cost for that house, and in this case, what is the square foot cost for the school. So we'll go back to 2017, once again, a couple years before COVID, this school was built for $170 per square foot. And so very good value then, very competitive number then, for that school and that time. Moving to Centerville Elementary School that was bid in 2019, you see $207 per square foot. There was an increase from the Beechwood number, but that's elementary to a middle. So when you build a larger school, you're going to get a better value, a better number per square foot. As you see, when you look at the Pillion Middle School number, which was $193 a square foot, that was bid in 2019. And then Lakeside Middle School bid in 2021. The building cost, $41 million, $41,060,000. The square foot cost, right there in line with Pillion Middle School, $191 per square foot. So moving to ES19 and moving to what we're looking at right now, if this school would have been bid in 2019 using the number for Centerville, $207 per square foot, an estimated building cost would have been about $26.5 million. And right now, this school has been bid, ES19, and the cost per square foot, this is a true number, is $316.57 per square foot. You multiply that out, you look at the building cost for ES19, $40,460,000 for this site, and then you see the site work cost there that is in line with, schools are site specific. You're not going to see a apples to apples in comparison with site work, and you see the number there for ES19's site work. That's the on-site, the development of the site, and then also the off-site work that goes along with that school that has been, provided to us by our work with SCDOT and the County of Lexington. We've seen, just to provide, once again, some framework, 3.5% escalation even since April of 22. So once again, we had that opportunity, through our enrollment pause to watch the market, to see, what was going to happen, to work with our contractors, to get feedback from other districts. And this is the number. This is a competitive number. We work with lots of other districts, and we communicate and, bounce ideas off each other. What numbers are you seeing? What's the market showing in other areas of the state? And this is a very competitive number, through our interactions and conversations with other school districts who have recently bid projects. So we feel like it's a number that the market is dictating now, and it's the number that it's going to cost to build this school. So moving to the total cost, for this school, provides you a breakdown of the total all-in construction costs. Anytime you build a school, obviously you have other costs as well. You have the design fees for that. You have the FF&E, which is the furniture, the fixtures, the equipment, all that goes inside the school. I like to say you pick it up. If you pick the school up, turn it upside down and shake it, everything that falls out, that has to be purchased as well. And so that's a part of this this projected cost. So you see the building cost that we just talked about, the site work cost, the FF&E, design, inspection fees, and that's an estimated total of, $55,550,000. So the total cost, the total request for this school is $56 million. That's what it's going to take to build elementary school number 19 and get that project started in January.
All right, going back to the handouts that I provided, we have some options for the board to consider for their vote next week.
Ms. Miller, can I ask him a question real quick before you get into that?
I was going to ask
Sure,
when we
sure.
can ask
So-
questions.
Yeah.
So, Mr. Warren,
Sure.
you said 18 months for this build,
Correct.
right? A lot can happen in 18 months. I think about what the market was 18 months ago versus what it is now. So if we get 12 months into this and the cost of things go down, we haven't purchased furniture and fixtures and equipment at that time. Could it go down? Is it going to go up? Or is this like a set dollar amount that we have an agreement with this company?
The set dollar amount that we have an agreement with is the building cost, the site work cost. We do sign, this is a CM at risk project where we sign a guaranteed maximum price document with the contractor for the building cost and the site work cost. Because
But we ended up having to pay like $9 million or $8 million, a lot more for Lakeside for site stuff, so
Yep.
that's a concern.
Well, and I understand that's a great question, but for this site, the site work here is established, the off-site is established. We have approved SCDOT plans for this school for the off-site work. So you won't see that with this project.
Okay, thank you.
But to answer your question about furniture, we don't buy furniture, in January. So we would wait typically, 4 or 5 months out from completion. So you could see some savings there, or you could not. So that's why we do have some inflation numbers built in. And my goal would be to not spend $56 million. That would be my goal. And of course, that would be, documented through our monthly presentations to the board to talk about, what we've spent, contract amount, any kind of change orders that have come in. So you'll see that along the way and be able to track that along with us to see how we're tracking towards that number.
Okay, so a couple questions. If you go back a couple slides when you were showing the bill cost of other schools, yeah, right there where you show the total building cost, is that the total cost with furniture and everything involved for those other schools?
No, this is just the building cost and the site work cost.
Okay, because it would be interesting to me to see how this 56 million compares to the actual total cost of those other schools.
And Chris, I think that's on this document that Ms. Miller has given us at the top. I think it's pretty close to total expenditures versus, is that right, Ms. Miller? The total expenditures on the project, because the top 5 lines are the 5 schools that are, Beechwood's not on it because it's not part of this bond. The long spreadsheet. So
That is correct. If you would look at this, Mr. Rice, and you could see the prices there for those schools.
that makes sense.
I guess the only other thought I had is, not trying to get into all of the district business, but do we incentivize our contractors in some sort of way to bring the cost in at a lower cost? Like, hey, if you can bring this in at a lower cost,
Well,
there's maybe
and I think, Mr. Marr, correct me if I'm wrong, but that's part of the CM at risk is that it's a guaranteed maximum price. And so I think that's where the incentive is that correct?
That's right, and we do have agreements with all of our CMR contractors. We do not participate in sharing any kind of savings. Those savings come back to us. And so, even though they have a guaranteed maximum price, they're submitting pay applications against, their GMP document. We're vetting those. We're making sure that, what you're charging us for this month, you have provided through your labor, it's like if you've ever built a house, we're not paying for all this up front. We're paying for this along the way through payment applications and us vetting that to make sure it's in line with the contract.
Okay, and then my last question is, looking at the Lakeside Middle School site work cost $16 million. I know you said it's not apples to apples. $16 million there, PU Middle School, $5 million. Looks like this one was in the $8 million range.
That's right.
Does that, I know you mentioned DOT, but we don't think there's any other additional road work we'll have to do or anything like that, or we'll be governed, by county or whatever to do in order to finish that project? I guess I'm asking, do we have all those questions answered ahead of time before we start cutting checks?
For this school, we do. And of course, the Lakeside site number, $5 million of that was the widening of Old Cherokee Road. And right now, for this Bluefield site, where it sits, the impact of the school, the off-site work is going to be very typical to other schools we've built. What you see at Centerville, what you see at Deerfield, those type of off-site improvements.
I just really quick wondered, does MBCon typically get all the bids? Or do you know if other builders have worked with us?
With our building, that's a great question. With our building program, MBCon, they did the work on the front end to provide us the facility study and the budget for the project. We assigned projects to the 5 contractors that we selected for this program. So this school was assigned to Thompson Turner Construction. So Thompson Turner Construction is the one who has gone out, they've advertised the project, they've taken the bids. We've met multiple times vetting those bids, looking at those numbers, making sure they're in line with where they should be. So MBCon didn't take part in the bidding of this project at all. That was Thompson Turner Construction.
I inherited the 2008 bond referendum when I came on board. The difference was we were in an environment of falling interest rates. And so we actually had, at the end of that referendum, had to make some decisions about where to allocate the remaining resources. So unfortunately, y'all were on the opposite end. You're inheriting a bond referendum with rising rates. And again, we're seeing overages in the hospital all over the place. And it's just the environment of a building environment right now.
I will just say to piggyback off that though, I feel like there is a lot of price gouging just because they can use that excuse. So that's something to just be leery about.
Any other questions? There'll be some time for that too at the end, so we'll let
Okay.
Jennifer go ahead.
All right, if you look at the packet I handed out, the second sheet, this is our 3 options of a funding solution. You can see at the top, the original projection was the $37 million. The revised projection is the $56 million. That leaves us with $19 million. Fortunately, we do have bid premium when we sold the bonds that has been held back, that has not been allocated to projects. So we have a bid premium amount of $11,600,000 that is available to offset this increase in budget. So each option includes that bid premium amount. You'll also...
Jennifer, excuse me, can you elaborate on that just a little bit about the bid premium?
So when you sell the bonds, you either sell them at a premium or a discount, and when you sell them at a premium, you actually receive more funding than what the original bond was for based on the rates of the economy at the time. And so that we sold at a good time. Right now, if we were to sell the remaining funds that are out there, we will probably have to sell at a discount and not get the $50 million exactly because of the way the economy is right now. But back when these bonds were sold, we received a premium. And my predecessors were smart enough to just hold back that money and have it sitting there in anticipation of rising cost and having it available.
So if we didn't, that was a good question. So if we didn't have to spend this 11,600,000, would it have to be spent on
It would still be,
capital stuff,
yes, ma'am, it would
Okay.
still have to be the bond referendum.
those projects?
Yes. All right, and then in also all three of the scenarios, we have other capital project funds. We have about 6.5 million that have been set aside for that. And then, as we discussed earlier, in the October report for the capital projects, we have approximately $800,000 from those projects that have closed that are remaining. So that leaves us with a $100,000 need. So I'm giving the board three options here. You could take the $100,000 and reduce the IT budget that was just approved this fall and take it from that and just not spend the $100,000 on any of those IT budget items. You'll remember you approved about $10 million in IT things, so you could just reduce that by $100,000. You could also take $100,000 out of the general fund balance and not have any impact to our unrestricted fund balance that's remaining. With a $75 million fund balance, $100,000 would not really impact that at all. Or you have option 3 where you could take a combination. I just did 50-50 just for the simplicity of the math, but the board could make a vote on however they wanted to split that. And then on the last page, as I mentioned, taking $100,000 or $50,000 from the unrestricted unassigned fund balance would not have an impact on our percentage of what we're required to have in our fund balance. Currently, the law is to have 8.33% of your general fund expenditures in an unassigned fund balance. That equates to about 1 month of operating expenditures. Good business practice would have about 2 to 3 months in there. So 2 months would be 16.67%, 3 months would be 25%. And so as you can see in that calculation, that percentage line, we are at approximately 23%, whether we take this money from the general fund balance or not. We're still at 23%, which is about 2.78 months, so just shy of 3 months of an unassigned fund balance.
What's the threshold for a bond covenants? Again, to keep our credit rating.
I do not have that specific threshold. I just know that we, the law is 8.33%. Usually anything over 2 months, really, you're in good standing over 2 months.
So as our chief finance officer, which do you think is best? Do you have a recommendation?
I do not have a recommendation on any of these three because they really do not impact the general fund requirements. So it would be whatever the board would decide to do.
Are these the only two funds that you would pull from? Are there any other places we spend money that maybe we could look at? From?
We cannot take anything out of your special revenue funds. Those are mandated by grants and state covenants of where those things can be spent. So we can't take it. It would have to come from the general fund or it would have to come from capital projects. And the capital projects we already know are going over. So really those are the only two options, general fund or capital projects.
Could you elaborate a little bit on I see the other capital funds, 6.5 million. What exactly is that?
That is where money has been remaining set aside for capital projects. Again, the designation would be for capital projects, and this would fit that designation of a need of a capital project.
So as you think about that and determine whether you have any further questions you'd like addressed tonight, we want you to know that these materials will be in your agenda packet for this coming Monday night. So you'll have the PowerPoint presentation as well as the link or actual handout, however Tracy puts it together. So you'll have these materials in your packet. But we felt that because this is so new for so many board members, I think probably there were just 3 board members serving at the time that the 2018 referendum was put together. We wanted to take a little bit more of your time tonight and just make sure that you have an opportunity to look at the options and decide which one you prefer. A vote affirmatively from the board next week would allow us to break ground on the school in January. If we don't break ground in January, we run the risk of not being ready to open the school in 2024. And as you saw, it would be very difficult. It isn't as if you're building a new replacement school and you'd be moving all the children from one school to another. You'll be primarily serving children in that neighborhood, but they're currently enrolled in other schools, so it would be nightmarish to try to staff the new school, plus figure out which staff is going where. It can be done, but it's not at all an optimal situation. And then again, I'll repeat that in early February, we will have a lot more time devoted to a workshop where we look at all the expenditures and what our options are regarding the final elementary school to build. We moved ahead to school number 19 because an agreement about where to locate school number 18 could not be reached when the purchase of a specific plot of land was recommended.
And school 18 that you're referencing is on this sheet Ms. Miller gave us, page 1. That's just the new elementary school. That's
Right.
what's listed there.
And that's
Which
set
is-
aside for that school.
That's the river Bloomington.
Right, and it's budgeted less than this
Correct.
one. So
Right.
before.
Right. And that's why we need much more time in February to figure out what our possible solution sets are and what is in the best long-term district.
We have a
long-term
deadline on the
interest of the
referendum
district.
money, don't we? Year-wise?
We should, so that people know, so that we help our county auditor with his job. It would be good for people to know, for the auditor to know by September, what bonds we're going to sell next year so that the tax notices are correct for the entire year. So that would be our goal, would be to make these decisions and get the new school underway as quickly as possible. And if we get approval by next September, then the next school could be underway.
January of '24.
So if there are no further questions tonight, we're available between now and next Monday. In particular, Matt and Jennifer, no answers. I can pass on your questions, but I wouldn't be able to answer very many of them because I'm just about as new to this as you are. So we appreciate your extended time tonight. We did put on your tables a copy of an article about a Stanford study about the impact of COVID on aging the brains of adolescents. We talked a little bit about this at one point, and we provided this article the old-fashioned way, just giving you a copy of it rather than a link to it, because we thought you might want to share it with others in your household. So, that concludes our presentation, Madam Chair.
Thank you very much. As a reminder, our next regularly scheduled board meeting is next Tuesday, December 13th, and that one is at 4:30 as well. And so come and eat your early lupper. I think that's what Dr. Powers called it, lupper. Yes. Do I hear a motion to adjourn the meeting?
Madam Chair, motion to adjourn.
Thank you, Mr. Anderson. Do I have a second? Thank you, Mrs. McCown. Any discussion? All right, all in favor, please say aye.
Aye.
Anyone opposed? Thank you very much. Have a good evening, everyone.